I appreciate it, sir. Thank you. You don't have to come out. Do you have to step out for you to give me the ID, sir?
No, she hit. I can follow y'all to the station.
No, that's how it works.
She hit me.
Ma'am, you're under
No,
arrest.
don't.
Get out of the car. Get out of the car.
You're losing your mind.
Yes.
Do not.
The red and blue hues of the police cruiser's light bar cut through the darkness of a March evening in Oaklawn, Illinois. It was March 19, 2024, and the scene on South Cicero Avenue was common for a Tuesday night. A vehicle sat idling on the shoulder, pulled over not for a moving violation, but for a disturbance that had just occurred moments prior. Inside the sedan sat a woman identified in reports as Miss Johnson. Accompanied by a male passenger, they had just departed a nearby Hooters restaurant. But their exit had been anything but routine. The radio traffic preceding the stop described a physical altercation. Allegations flew regarding a customer assaulting an employee. Now, the adrenaline of a bar fight met the cold procedural reality of a police investigation. The officer approached the driver's side window, body camera recording every pixel of the interaction. He did not come in hot or aggressive. He approached with a casual, almost conversational tone. "Hello, how you doing?" the officer asked, leaning slightly to hear the driver. Johnson responded that she was okay. The officer wasted no time in establishing the premise of the detention. "Good. So, obviously you know why I pulled you over, correct?" This is a standard investigative technique. It invites the subject to incriminate themselves before they even know what the officer knows. Johnson played coy initially. "For what?" she asked. The officer dropped the pretense. "What? What just occurred in the Hooters?" The investigation had officially begun. The gap between the chaotic emotions of the restaurant and the legal jeopardy of the street was about to close. The backdrop of this incident involves the complex social contract of dining out. Establishments like Hooters serve alcohol and food in a casual environment. Patrons expect leisure, while staff members are tasked with enforcing rules regarding alcohol consumption and conduct. When these expectations clash, the result is often a call to 911. In this specific instance, the dispute centered on an open container of alcohol. Illinois law and restaurant liquor licenses strictly prohibit patrons from removing open alcohol from the premises. Staff members are legally obligated to prevent this. Failure to do so can result in fines or license revocation. This was the pressure point that sparked the conflict. Johnson's version of events began to spill out rapidly. "I don't know. She pushed me," Johnson claimed, referring to an employee. The officer acknowledged the claim but remained focused on securing the scene. "She pushed me? Okay. Give me a sec. Let me get your ID while we're at it right here." He took her identification, a standard Illinois ID card, and shifted his attention to the logistics of the investigation. He radioed his partner, Unit 311, who was currently at the restaurant interviewing the staff. 311 from 312. "You can go ahead and go to the Hooters. I got the offender here. I'll try to get the story from her so you can get the story from them." This coordination is vital. It allows officers to compare the physical evidence and witness statements against the suspect's own admissions in real time. The officer turned his attention back to the occupants. He asked if they had just eaten food, keeping the tone light to prevent early escalation. He then engaged the passenger. "Who's this gentleman in the passenger seat there?" Johnson identified him simply as her friend. The officer requested the passenger's ID. "May I have that?" "Sir, I appreciate it." The passenger complied without argument. He remained calm and quiet throughout the encounter, a sharp contrast to the driver. His behavior illustrates a survival strategy often seen in traffic stops. Compliance and silence minimize personal risk. He provided his identification and sat back, letting Johnson handle the talking. The officer returned to the central issue. "So, walk me through. How long have you been at Hooters?" Johnson explained they were sitting down and eating. Then she introduced the conflict. "A girl just came out of nowhere," she said. The narrative of the aggressor appearing from nowhere is common in assault statements. It attempts to remove any prior context or provocation, but the officer pressed for the sequence of events. "Okay, And then what happened? Johnson's next sentence would become the cornerstone of the state's case against her. She pushed me and I hit her ass back. In the eyes of the law, this was a confession. Johnson had just admitted to a battery under 720 ILCS 512-3. Battery occurs when a person knowingly, without legal justification, causes bodily harm or makes physical contact of an insulting or provoking nature with an individual. By saying I hit her ass back, Johnson placed herself squarely within the statute. She attempted to frame it as retaliation or self-defense. However, the law regarding self-defense requires proportionality and a lack of other options. The officer recognized this immediately, but played dumb to get more details. "What was the push for?" he asked. Johnson's defense began to fracture. "I don't know. You told." "No, I don't know. I literally just got here." The officer challenged the vagueness of her story. "She assaulted me." Johnson insisted. "How did she assault you? I mean, you need to give me more than what you're just telling me right now." The officer countered. He needed specific actions, not conclusions. He walked her back to the moment of the conflict. "You're sitting down. You're eating your food." Johnson repeated her refrain. "She pushed me and I hit her back." The officer probed for a motive. "What was the reason why she pushed you?" Johnson claimed ignorance. "I don't know." The officer highlighted the absurdity of the claim. "So, she just randomly went up to you and punched you for no reason as I was exiting on the door?" The inconsistency in Johnson's story was growing. First, she was sitting down eating. Now, she was exiting on the door. The spatial dynamics of the story did not align. The officer pressed further. "There was no words exchanged or anything like that prior to the push?" Johnson denied it. "I don't remember none of that." Memory loss regarding the moments leading up to a fight is a common indicator of deception or intoxication. It is convenient to forget the provocation while remembering the victimization. The officer advised her to sit tight. "We're going to try to figure this out." While waiting for his partner to report back from the restaurant, the officer continued to engage Johnson. He wanted to clarify the nature of the hit she admitted to. Johnson refined her statement. "She pushed me, and I threw my drink at her." This admission changed the complexion of the case. Throwing a liquid at someone constitutes battery of an insulting or provoking nature. It is a deliberate act of aggression. The officer sought the trigger for this escalation. "Okay, but why would someone just push you for no reason?" Johnson became defensive. "She pushed me, and she hit me in my goddamn eye." The officer asked for the cameras to be reviewed. "Run the cameras," Johnson demanded. "Well, they will do that," the officer assured her. This demand often backfires. Suspects frequently believe video evidence will vindicate them, forgetting that it captures their retaliatory actions just as clearly as any provocation. Johnson remained adamant. "I'm not a provocative person, but if somebody put their hands on me, I will defend myself." This statement reveals a misunderstanding of self-defense laws. Retaliation is not defense. Once the immediate threat is over, or if the response is disproportionate, like throwing a drink in response to a block or a push, the legal protection of self-defense evaporates. The investigation took a turn when the officer probed the alcohol issue. "You had a little cup." "What was in the little cup?" Johnson admitted. "Some of that little liquor." She then inadvertently provided the motive for the employee's intervention. "She told me that she just ran to the door, was like, 'You can't leave with that.' I was like, 'Okay, I want to sit down.' And then she was like, 'Well, there's nowhere to sit.'" The pieces fell into place. The employee was enforcing the no open container rule. Johnson tried to stay, but there were no seats. The conflict arose from the refusal to surrender the alcohol or leave without it. Johnson described the physical altercation again. "She pushed me, and I threw a drink at her, and she swung at me and we was fighting." The phrase "we was fighting" suggests mutual combat rather than one-sided aggression. In Illinois, mutual combat can sometimes negate self-defense claims for both parties, but often both are charged with battery, disorderly conduct, However, throwing a chemical or liquid into someone's face is viewed harshly by the courts. It is demeaning and carries risks of eye injury. Johnson continued to justify her actions. She escalated all that. I told her, I need to sit down. The officer received confirmation from his partner at the scene. The witnesses and victim corroborated the drink throwing. The decision was made. There was probable cause for an arrest for battery. The officer approached the vehicle again. He ran the ID, not just as a card, but as a driver's license check. It's going to be an Illinois ID card. Run it as a DL. He instructed dispatch. This ensured he knew the status of her driving privileges. The formalities were complete. It was time to effect the arrest. Miss Johnson, step out of the vehicle for me. The officer commanded. This lawful order is backed by the Supreme Court decision in Pennsylvania before MIMS 1977, which allows officers to order drivers out of a vehicle during a lawful traffic stop for officer safety. Johnson refused. No, the refusal to obey a lawful order marks the beginning of a secondary crime, resisting or obstructing a peace officer. The officer remained patient but firm. Can you please step out of the car for me? Please, I'm going to ask you one more time before I pull you out. I already told you because you're going to be placed under arrest battery. Johnson attempted to negotiate the terms of her arrest. No, there is no white shirt. We don't have any white shirt. No. Ma'am, she was likely asking for a supervisor. Often referred to as a white shirt in some jurisdictions, the officer denied the request. As there is no legal requirement to have a supervisor present to effect a misdemeanor arrest, you can speak to them at the station, he explained. Johnson offered an alternative. I can follow y'all to the work. She wanted to drive herself to the station, avoiding the indignity of handcuffs and the back of a squad car. This is never permitted. An arrest takes custody of the person immediately. Ma'am, you're under arrest, the officer repeated. You've been told you're under arrest. So, it's going to be last and final opportunity I give you, or else you're going to be pulled out of the vehicle. Johnson dug in. No, you're not. This defiance crossed the threshold from verbal noncompliance to active resistance. The officer opened the door. Yes, I am. Johnson clung to the vehicle's interior. Don't. The officer and his partner moved in. Okay, then get out of the car. The physical struggle ensued. Under 720 ILCS 53-1-1. A person commits the offense of resisting or obstructing a peace officer when they knowingly resist the performance of an authorized act. The arrest was authorized. Johnson's refusal to move and her physical bracing against the officers constituted the actus reus of the crime. Get out of the car. Get out of your mask. The officers commanded. Johnson screamed. What are y'all doing? It is a common psychological reaction during arrest. The reality of the loss of freedom triggers a fight-or-flight response. Johnson chose fight. You're going to get another charge if you don't step out of the car now, the officer warned. This was a clear notification of the consequences. Johnson ignored it. Officers physically pulled her from the driver's seat. You're under arrest. Let me go, she shouted. They moved her to the rear of the vehicle to secure her. Put your hand behind your back. You're under arrest, they instructed. Johnson continued to struggle, pulling her arms away. Don't do it. Give me my phone. Give me my phone now, she demanded. Her priority was her property, not her compliance. The officers forced her to the ground to gain leverage. This is a standard takedown technique when a suspect refuses to yield their arms while standing. Get on the ground, they ordered. Johnson continued to scream. Baby, let me go. Let's stop. She called out to her passenger, who remained in the car, helpless to intervene. Ma'am, you're under arrest, the officer said, his voice straining with the physical effort of restraining her. Johnson's resistance was active and continuous. She refused to give up her hands. I cannot breathe, she yelled. The claim of "I can't breathe" has become a charged phrase in modern policing. Officers are trained to assess the airway and breathing of a suspect immediately upon hearing it. In this case, Johnson was speaking in full sentences and screaming at high volume, indicating her airway was patent. The officers adjusted her position. "Okay. Relax. Stop fighting." One said, "Let go of your sweater." Another commanded. Realizing her grip on her own clothing was preventing them from handcuffing her, the struggle was messy and loud, playing out on the asphalt of Cicero Avenue. Johnson's passenger watched from the car. "Baby, do not come up. Do not come up to us." Johnson yelled to him, "They're killing me." This hyperbole is dangerous. It can incite onlookers or associates to intervene, creating a deadly force situation. Fortunately, the passenger stayed put. Officers managed to secure the handcuffs. "Got one," an officer announced. They rolled her onto her side. The recovery position, to assist her breathing. "All right, get on your side. Put your knees to your chest." Even in handcuffs, Johnson remained combative. "No, you was not helping me at all." She spat. The officers tried to help her stand. She went dead weight, then thrashed. "That hit me," she screamed, referring again to the Hooters employee. Her focus oscillated between the arrest and the original slight. "Baby, give me my phone," she pleaded again. The officer informed her, "It's coming with you." He tried to de-escalate her anxiety about her property. "Relax. No, it's not worse." They walked her to the squad car. Johnson accused the officer of inappropriate touching during the search incident to arrest. "Do not touch me. You are not a quiet," she said, her words slurring slightly. I'm taking your bag off." The officer explained objectively. He was removing a crossbody bag which could contain weapons or evidence and poses a strangulation risk in the back of a squad car. Johnson protested. "That's my private part. I'm touching my bag." The officer corrected her. "No touching your private car?" He likely meant part or was correcting her assertion. The search was necessary and lawful. Once inside the vehicle, the reality set in. Johnson asked for a condition report or some medical acknowledgement. "Can you just uncuff me?" she asked, her tone shifting from aggressive to bargaining. "No," the officer replied flatly. "You are under arrest. You actively resisted." Johnson denied the resistance instantly. "I did not. I was talking to you." This disconnect is common. Defendants often equate talking or arguing with compliance. The law does not. Arguing while refusing to move is resistance. The officer explained the situation regarding the passenger. "My partner's at the Hooters right now, talking to whoever you allegedly claimed that pushed you." He clarified that the investigation was thorough. Johnson's behavior in the car continued to be erratic. She kicked at the door. "Do not do that to me," she yelled. The officer warned her again. "I'm going to go through your purse. This is a standard inventory search or search incident to arrest, depending on the status of the bag." Johnson claimed, "I don't have nothing in my car." The officer was unmoved. "What do you think I am? I got to work every day." The arrest of Miss Johnson illustrates the cascading effects of a single poor decision. The initial incident of battery at a restaurant was a Class A misdemeanor. It carries a maximum sentence of 364 days in jail and a $2,500 fine. However, first-time offenders often receive court supervision, community service, or anger management. By refusing to exit the vehicle and fighting the officers, Johnson added a charge of resisting arrest, another Class A misdemeanor. These charges run consecutively in terms of legal processing. The resistance also provided the state with evidence of a lack of impulse control, which prosecutors can use to argue against leniency. The legal standard for the initial stop was reasonable suspicion based on the 911 call describing the vehicle and the fight. This is the Terry standard. Once Johnson admitted to throwing the drink, I threw my drink at her. The standard elevated to probable cause. This authorized the arrest. The order to exit the vehicle was the procedural bridge between the investigation and the custody. Her refusal was the breaking point. The use of force pulling her out. Taking her to the ground was legally justified by her active resistance. Officers are trained to use the minimum force necessary to overcome resistance. When she pulled away and braced, they used leverage and body weight. The role of alcohol cannot be overstated. Johnson admitted to drinking some of that little liquor. Alcohol disinhibits behavior, making a person more likely to throw a drink when offended and more likely to fight police when confronted. It impairs the executive function required to weigh the consequences of hitting her ass back or saying no to a police officer. The hearing impaired claim she made earlier, "I got my grandma ears," likely played no role in the resistance, as she clearly understood the commands to get out and responded verbally with no. The impact of this arrest extends beyond the jail cell. Johnson's vehicle was likely towed or turned over to the passenger if he was sober and licensed. She would face booking, fingerprinting, and a bond hearing. The public nature of the arrest, captured on body camera, creates a permanent digital record. For the community, it reinforces the connection between alcohol consumption and public disturbance. The Hooters staff, victimized by the assault, must deal with the trauma of a physical attack in their workplace. Service workers are increasingly the targets of customer violence, a trend that destabilizes the local economy and labor force. The passenger's behavior serves as a lesson in legal self-preservation. He provided ID, answered questions politely, and did not interfere with the arrest. Consequently, he went home. Johnson, conversely, argued every point, admitted to the crime on tape, and physically fought the process. She went to jail. The contrast highlights the importance of emotional control during police encounters. From a procedural standpoint, the officers followed the textbook escalation of force. Verbal commands first. Step out. Repetition. I'm gonna ask you one more time. Warning of consequences. You're going to get another charge. Soft, empty hand, control guiding her arm. Hard, empty hand control pulling her out. Takedown. At no point did they strike her or use weapons like a taser. Despite her screaming, they monitored her medical status, run the air. Get on your side immediately after the handcuffs were on. There are critical lessons here for the public. First, the side of the road is not a courtroom. Arguments about the validity of an arrest should be made to a judge, not the arresting officer. Once an officer decides to arrest, verbal debate will not change the outcome. It will only add charges. Second, self-defense has a strict legal definition. Retaliation after the fact is not defense. Throwing a drink is battery. Third, the right to remain silent is a powerful tool that Johnson abandoned immediately. Had she simply handed over her ID and said nothing, the officer would have had to rely solely on the witness statements. Her confession, "I hit her ass back," closed the loop on the investigation before it barely started. The video ends with Johnson in the back of the cruiser, the door closing on her protests. The red and blue lights continue to spin, illuminating the scene of a preventable escalation. A dinner out became a criminal record because of a lack of emotional regulation. The encounter serves as a stark reminder. When the law intervenes, compliance is the only path that leads home. Resistance leads only to the ground.